Have board members have a fiduciary responsibility, a relationship of trust. Fiduciary means trust, a relationship of trust with the owners. And board members are expected to act in good faith. And what that also means is that you have to treat people be professional in treating owners. You have to be respectful of the process, and you have to follow the law. And the other thing boards do not have, they do not have the discretion to ignore bylaw breaches. So let me give you an example. Your particular condominium complex is 32 units. You have a set of bylaws that say no pets, period, full stop, no dogs, no cats, no nothing. Charlie Brown in unit 101 recently his spouse died, and because he was so lonely, acquired a cat, and he is now the happiest man around to have that cat around him. Everyone loves Charlie Brown in the building. Unfortunately, you as a board cannot sit there and go, let's ignore that because it's Charlie Brown. Charlie Brown is in breach of the bylaws. And as a result of that, the board will need to take steps to deal with that breach. Now, what typically happens in these cases is Charlie Brown then says, well, my cat is my emotional pet. And if you take that cat away, you now are breaching my human rights legislation. And then you're getting into a big fight. But the problem is this, and of course, the law is not that clear in that regard, but what is clear is boards don't have the discretion to ignore bylaw infractions. And so as a result of that, boards need to deal with them properly. And again, at the initial stages, your property manager and the board work together to address that particular breach or alleged breach. But when things start to escalate, that's when you need to engage legal counsel to assist you in making sure that you are doing things properly. And let me give you a real life example of this. I acted for an owner, a woman in Edmonton who did not speak a word of English. She was Asian. Her son lived with her as well, but she was the only one on title. Her son lived with her and was an adult and lived with her. And of course, her son was her key person to help her with English because he spoke both Mandarin and English. They also had a dog, which was not outside the bylaws. However, someone made a number of complaints against the dog, alleging that it was tracking mud in the building, alleging that it was defecating on common property and the owners were not cleaning up. And the list goes on. And the condominium corporation, through the board, through their property manager, the board and property manager, and by the way, it was not Magnum York, they started issuing fines to the owner. And those fines were significant. At some point, they reached the $4,000 mark, and then in the manner in which they were issuing them. Those fines remained unpaid. And as a result, the condominium corporation decided to go to court, hire a lawyer, not me, someone else. I acted for the owner. And they went to court to ask the dog be removed from the unit, that the owner pay the fine amounts, that the owner reimburse the corporation for all of their legal costs, and to evict her son from the unit. So the condominium corporation decided to take out all the weapons and go after this poor woman who obviously could not speak English and relied on her son, but the condominium corporation wanted really stick it to her. As a result of that, she came to me when we defended this. What became very clear in the questioning or through the litigation process, the fine amounts that were issued by the board against her were amounts that were contrary to the law in Alberta. What we also discovered that the photographic evidence that they had of defecation on common property, they couldn't tell me who took the pictures. They couldn't tell me which dog that was. They couldn't tell me the date or time these photos were taken. They had photographs of mud in the hallway. Again, they could not tell me where the mud originated. They thought it was there, but they're alleging that it was theirs. But again, the board president, had no evidence at all. And at the end of the day, their claim was dismissed. And at the end of the day, too, the condominium corporation was reimbursed the owner their legal fees, my fees, and they paid us over $60,000 in legal fees to reimburse this owner. And on top of that, if there was a special levy that was issued to repay me and their own legal fees, my client were exempt from that. They didn't have to pay the special levy for these legal fees. What this case really tells me is a couple of things. Number one, a lot of people dropped the ball, both the property manager and the board. So number one, if you're going down a path where you're going to take legal steps, you need to engage the lawyer at the beginning of the process. This poor lawyer who came in for the condominium corporation, it's pretty hard to fix a cake that's been baked so badly. I could put a little frosting on it, but it's not going to improve the taste. You already made a bad cake, and now you've asked me to fix it for you as a lawyer. It's hard sometimes. But if you had involved me in the kitchen when we were mixing the ingredients, and I could be there to help you with those ingredients, we can bake a better cake. That's number one. So I appreciate you may say, well, we don't want to spend the money. Well, here's the thing. As this condominium corporation experience, pay me now or pay me later. Because if you're not going to do this properly, your exposure is significant. In this case, it was. Number two, if you're going to go after an owner for a particular breach or alleged breach of a bylaw, you need what we call is evidence. And that means dates, times, people who actually took the photos, what those photos mean, specifically so that a proper story can be told. Someone was clicking pictures, but no one was ever documenting what those photos were. And I can tell you this, if you don't document it, months pass or years pass, you will not remember. And the other important thing to keep in mind is this. If you're going to issue fines, follow the law. You can't issue a fine for $1,000 because that's what you think you want to do. You still have to follow the law. And again, here, they did not. And so, again, if you are going to make a court application against an owner, and you're going after them for some extraordinary court order, in this case, the removal of a dog. Imagine your pet dog that you've had for years, and some third party coming along saying, we want it gone. Can you imagine that? And the other thing too, can you imagine coming to court saying, we also want your son, who's your only voice, to be removed from the unit? So if you're going to be that aggressive against an owner, you better have all your I's dotted and your T's crossed, because if you don't, this is what's going to happen to you.